Good morning, everyone. Welcome to today's employment seminar. My name is Marty Rabinovitch. I am a partner at Devry Smith Frank, and I head up the firm's employment law group. So welcome to everyone, and thank you for joining in this morning. So this program has been approved for continuing professional development hours under Section A for human resources professionals through the HRPA. So for all you human resources professionals who are in attendance today, make sure you get the code from our firm's marketing department so you can claim your hours at the conclusion of the program. For any lawyers who may be in attendance today, the program is eligible for 1 hour and 30 minutes of substantive content through the Law Society. Here is a look at the agenda for today. So the seminar will run until 10:30. There are 3 topics that we will be covering. The first is COVID-19 vaccination policies in the workplace, updates, tips, and considerations for employers. We will then look at the impact of COVID-19 on the reasonable notice period. We'll do a quick case law update for you. And then we will get into the employer's duty to deal with employees in good faith and moral damages, and we'll do a bit of a case law update there for you as well. All of the topics will take about an hour combined. I will tell you right now, the COVID-19 topic is a little bit longer than 20 minutes, but the other 2 are a bit shorter. So in any event, the content will last about an hour before the break. We'll take a break at approximately 10:05. During the break, I will review any questions that you may have. So if you do have any questions throughout the presentation, please feel free to submit them through GoToWebinar, and I will review them during the break, and I will answer as many of them as I can during the Q&A period. I will answer what I anticipate to be the most frequently asked question right now, and that is, will the slides be available? The answer to that question is yes, they will be available. They will be posted to our firm's website shortly after the presentation. If you would like to get a copy of the slides even more quickly, feel free to send me an email and I will respond back to you with a copy of the slides. So let's get right into it. We will start with our first topic about COVID-19 vaccination policies in the workplace. So here is the agenda for this topic. I'm not going to read out every subtopic here. You'll see as we go through the presentation. So let's get right to it. So a little bit of basic background here. You've all been reading the news about the pandemic for the last little while. But vaccines are very, very helpful. They help to build up and strengthen people's immune systems, providing protection against disease, including COVID-19. Now, the COVID-19 vaccines that are authorized for use in Canada have been shown to be safe and effective. That's why they are approved here. We don't approve vaccines that we don't think are safe. The vaccines are available free of charge to anyone in Canada. Now, Pfizer and Moderna have now received full approval under Canada's food and drug regulations. For a while, it was an emergency type approval. AstraZeneca had interim authorization, which expired on September 16th of 2021, so very recently. AstraZeneca does not actually have full approval yet. That is under review, but that vaccine, I guess for a second dose, not the first dose, is still going to be available for Canadians. So let's look here. So A few more basic points about the vaccines. If someone has already had COVID-19, you still should get vaccinated. When we're talking about side effects, generally speaking, the side effects are mild. There have been some serious side effects that I'm sure you've heard about in the media. Those do tend to be rare. There's no evidence right now that COVID-19 vaccines compromise fertility or cause problems with pregnancy. And there's also no evidence to suggest that in the amounts at which they are administered, that the ingredients in COVID-19 vaccines would be harmful. So overall, these vaccines are safe. Let's take a look at this quick slide about hospitalizations due to COVID-19. If you take a look at these charts here, it's pretty clear that the vast majority of people who have been infected with the virus who are in the hospital, either in the ICU or not in the ICU, are unvaccinated. Yes, there are some breakthrough cases that we're seeing among the fully vaccinated, but the vast majority are unvaccinated who are ending up in the hospital. So employers have a statutory duty to protect the health and safety of their employees. And that duty comes from primarily the Occupational Health and Safety Act. So employers need to take reasonable steps to maintain a safe work environment and protect workers from illness and injury. If an employer fails in this duty, then employees would be justified in not coming to work. So when it comes to COVID-19, taking measures to protect its employees from contracting the virus is a reasonable and I would say required step to protect their employees. Now, there's some questions here which haven't been totally answered yet by the court. So one question to consider is, well, will requiring all employees to be vaccinated be considered a reasonable step to prevent a COVID-19 outbreak? And I'm going to suggest to you that really this is going to depend on many factors, the main ones being the type of workplace and the position held by the employee. So if you're looking at workplaces like hospitals, old age homes, schools where there's going to be unvaccinated kids because there are no approved vaccines yet for kids under 12, arguably a mandatory vaccination policy or a vaccination requirement would be a reasonable step. If we offer a complete, contrasting, example to, employees who work, exclusively or almost exclusively at home, and the company says, well, now everyone has to be vaccinated, but yet, none of the employees ever set foot in the office. Well, it would be hard to link a mandatory vaccination policy to a legitimate health and safety objective in a case like that. Another question to consider is a mandatory vaccination policy as a potential defense to litigation from an employee who contracted COVID-19 in the workplace. I would say yes, if an employer can point to a mandatory vaccination policy in defense of such litigation, that would be a strong defense. Doesn't guarantee victory though. For example, just because you have a mandatory vaccination policy, but don't enforce, masking, social distancing, hand washing and so on, you still might lose that case. But as a side note here, for those employers out there with WSIB coverage, if an employee claims to have contracted COVID-19 in the workplace, the recourse there is going to be through the WSIB. We should also remember that vaccination is already mandatory in other parts of public life. The big one here is schools. So primary and secondary schools do require proof of immunization for students. This is under the Immunization of School Pupils Act. Fines and penalties can ensue if your children are not vaccinated. But note as well, in that statute, there are exemptions for medical reasons, conscience, and religion. As of September 22nd of this year, which is tomorrow already, proof of vaccination will be required for all businesses and organizations which have indoor spaces which are open to the public where masks cannot be worn at all times. So some examples there are restaurants, meeting and event spaces, sports facilities, concerts, and movie theaters. And a failure to comply can result in fines and penalties for everyone, businesses, organizations, and individuals, and these penalties would be under the Reopening Ontario Act. Okay. So let's look at some of the legal risks here. So if an employer does not take reasonable steps to prevent a COVID-19 outbreak, there could be an exposure there to legal liability. Again, subject to WSIB considerations for those employers who have coverage there. We talked a little bit already about a mandatory vaccination policy as a potential defense to a negligence action. Another piece of legislation that is helpful is called the Supporting Ontario's Recovery Act. And what that statute says is that there is no liability for an employer if they follow the public health guidance and all laws related to COVID-19 or make good faith efforts to do so, as long as any act or omission does not constitute gross negligence. Now, for the most part, at least, this act seems pretty clear, but like a lot of these issues pertaining to COVID-19, the statute has not yet been judicially considered. So the courts one day will have their say on what exactly that means, but I would say that overall this is definitely a positive piece of legislation for employers. Some other legal considerations about vaccination policies. One is human rights legislation. So employers will have a duty to accommodate under the Human Rights Code those who are unable to get vaccinated based on religion or disability. A medical condition is included within disability or other protected grounds under the Human Rights Code, although to be honest, I'm not really sure right now what other grounds would really be applicable. Now, the accommodations are up to the point of undue hardship. So in assessing undue hardship, the only two factors that are relevant as per the Human Rights Code are cost and health and safety considerations. And obviously the health and safety considerations are going to be big here when you're dealing with a COVID-19 vaccine. Privacy issues should also be considered. So as an employer, you may have some employees who refuse to disclose their vaccination status on the basis that it constitutes personal health information. Again, this issue has not been specifically decided by a court or other judicial body of which I'm aware right now. However, in my view, the employer will likely be entitled to that information about vaccination status as long as there is a policy in place which addresses the confidentiality issues. So the policy should set out things like why the employer is collecting the information, how its confidentiality will be protected, who will have access to it, how it's going to be used, where on the company's system it will be stored, and for how long it will be kept by the employer. And I'll give you a little hint here. The answer to most of these questions is going to be to comply with an employer's health and safety obligations under the Occupational Health and Safety Act. So Employees may commence a human rights complaint for failure to accommodate if the employer does not meet its accommodation uh, obligations under the Human Rights Code. Examples of accommodations would be things like permitting to have an employee continue working remotely, require the COVID-19 screening, although really that all employees should be doing the daily screening, regular or even daily rapid testing, requiring extra strict distancing, requiring masks, maybe even having an unvaccinated employee work in a specific part of an office building, perhaps even with a separate entrance to really keep them physically apart from the other vaccinated employees. If you haven't introduced a vaccination policy yet, and you're really trying one sort of last push before moving to a policy, employers could also try incentivizing employees to get vaccinated. Examples here would be to provide paid time off for them to go get a vaccine, try to arrange a vaccination clinic right at the workplace so it's really convenient for them, or maybe even to offer a gift card or some sort of other monetary incentive in exchange for providing proof of vaccination. Now, one quick note on that last example with the monetary incentives. If that's a policy that you adopt as an employer, you would also need to give the incentive to an employee who is unable to vaccinate for a human rights code reason to stay compliant with the human rights code. In terms of what's enforceable and what's not, it's still too early to tell for sure what exactly will be enforceable, because there is still no case law which addresses the issue. It's coming, but just not yet. Really, it will depend on the type of workplace and the job duties of the employee. Okay. As we learn more about the vaccines and the virus and their variants, the enforceability may change. What if we get a new variant after Delta that is even more transmissible, and the evidence indicates that the vaccines that we have now are still very effective at preventing, against severe disease? That's going to help employers out who want to have those policies. Some additional questions here. Does placing an employee on an unpaid leave for refusing to get vaccinated in contravention of an employer's policy constitute constructive dismissal? Well, I think here it's really going to come down to, whether you have an enforceable policy and, whether the policy, is overall reasonable. Give you one quick example. I mean, let's say you have a medical employer who introduces a policy that everyone has to get vaccinated, and the only exceptions are human rights code exemptions. But you've got an office employee, who spends 99% of their time, working from home, who doesn't want to get vaccinated, right? When you apply that policy, to that particular employee, it's not going to be discriminatory if the employee doesn't want to get vaccinated for a human rights code reason. But the employer might potentially run into issues there if they try to terminate that employee for just cause and not pay severance. If you look at this question more directly from a constructive dismissal lens, is introducing a vaccination policy a reasonable change which the employee will need to accept? Or, is this change going to be a fundamental term that, is being unilaterally imposed by the employer? Again, it really does depend on the context. If you're looking at terminating an employee for willful misconduct and just cause for refusing to get vaccinated, you may be able to do that. Again, it really depends on the context. So I would highly recommend consulting with a lawyer before terminating anyone for cause for not getting a vaccine. Now, that being said, if your goal as an employer is to have a fully vaccinated workplace, and someone says to you, well, I'm not getting vaccinated because I'm worried about, what might happen to me in 3 years, and I'm just still not comfortable with these vaccines, and there's no legitimate, medical or religious exemption, the employer could absolutely, terminate without cause, provide a severance package, and then make efforts to replace that employee with a vaccinated employee. So it's ultimately going to be a balancing exercise here. Can an employee be accommodated while maintaining a safe workplace at the end of the day? And a quick note here that a personal belief, a general concern about vaccines, or vaccine hesitancy, those beliefs are not protected by the Human Rights Code. So employers can certainly look at refusing to hire unvaccinated employees subject to the Human Rights Code. So an employer, could say during a job interview, well, we have, a mandatory vaccination policy, which essentially says that everyone here needs to be vaccinated subject to the Human Rights Code. For unvaccinated employees, employers can certainly impose requirements on them, such as, rapid testing on a daily basis or other regular basis. Terminating unvaccinated employees, yes, just watch out for human rights issues and just be extra careful if you would like to terminate for just cause and willful misconduct. Without cause, as long as there's no claimed medical or religious exemption, is much more straightforward. This is a quote from Ina Chadha, the Chief Commissioner at the Ontario Human Rights Commission. And she says, requiring proof of vaccination to ensure fitness to safely perform work or protect people receiving services or living in congregate housing may be permissible under the Human Rights Code if the requirement is made in good faith and reasonably necessary for reasons related to safety. So there's a nice summary of what we're talking about, and that quote should be encouraging to employers. Let's just look at the exceptions in a bit more detail. So medical exemptions, I think, are going to be generally difficult to obtain. There may be, other than the two that I'll talk about shortly, there may be some other examples, but we'll see. So the two that would seem to count are, number one, if someone is allergic to any of the ingredients contained in the vaccines, or if they have suffered from a severe side effect from the first dose. So those would probably be a legitimate medical exemption in terms of getting exempt from the second dose. There may be other medical conditions or personal medical situations that may count. I would sort of defer to the medical community on that. But my view is that generally, while of course not impossible, medical exemptions are likely to be difficult to obtain. Let's look at religious exemptions. So to be eligible for a religious exemption, the employee would have to demonstrate a sincere and honest religious belief, which calls for a particular line of conduct. There needs to be some sort of connection to the spiritual or divine. The employee must suffer harm that is not trivial, and overall there needs to be a balancing act against the rights of others. And this comes from a case decided by the Supreme Court of Canada called Absalom. And then if we're looking specifically at the Human Rights Code, any infringement on religion is going to need to be balanced with health and safety concerns. Now, although this is not the test in accordance with Absalom, it really comes down to a sincere religious belief and not really based on what a mainstream religious faith believes. But I would just note that there do appear to be very few religions which outright advocate against vaccinations for religious reasons. So again, religious exemptions are not impossible. I'm sure, you know, some will be granted. But if I were to gaze into the crystal ball, I'm going to say that generally speaking, they will be difficult to get. In terms of unionized workplaces, I'm not going to go through all of the slides in this section. I'll just comment that in the unionized world, it can be more difficult to implement and enforce a mandatory vaccination policy. However, at least based on what I'm seeing so far, it appears that many unions are not intending to challenge the policies themselves, but what they are telling their members, generally speaking, is that they will be open to submitting grievances if an employee is disciplined or terminated pursuant to a vaccination policy. So I'm going to just skip through these slides. This issue was covered in the last seminar, but again, the slides are available and you can look at them at a later date should you wish. Let's look at some specific considerations now for the federal government employers, which is the largest employer in the country. Our government has said that vaccination will be required for the entire federal public workplace as of the end of September. With the election results, I think, almost finalized, it looks like we are going to have the same government. So we will see, though, what exactly that means, because I don't think there have been too many details released on what exactly the requirements will be. The Charter of Rights and Freedoms applies to government employers, specifically Section 7. May be relevant here, which guarantees the right to life, liberty, and security of the person. So there may be some who have or who will like to challenge vaccination mandates based on Section 7. Once again, this issue has not been specifically addressed by the courts, but a vaccine mandate is not actually a forced vaccination. So in other words, no one is actually suggesting that an employer can, you know, physically force anyone to get vaccinated. So there's some question as to, you know, whether this section of the charter, you know, would even be triggered, because one example of the way that it's been used, you know, is respect to, you know, prison sentences and, you know, imprisonment, for example, right, which is not what's happening here. And the charter is also subject to reasonable limits under Section 1. So even if there were to be a breach of Section 1, the breach might ultimately be upheld as a reasonable limit under Section 1. On August 20th of 2021, there was a news release from Dr. Davila, who is the Toronto Medical Officer of Health. And Dr. Davila recommended that workplace vaccination policies first be introduced and require a whole bunch of minimum entitlements, or minimum requirements rather. And essentially they come down to you know, requiring workers to provide proof of their vaccination, you know, unvaccinated employees to provide, you know, the medical exemption, and note that that would also, or should include, whether the reason, whether we're talking about a permanent medical restriction or whether it's only for a period of time. She's recommending that unvaccinated workers complete an education course on the risks of being unvaccinated. There should be privacy concerns that are addressed, and that all of the health and safety concerns should be dealt with. So testing and personal protective equipment and ventilation and so on. So in conclusion here, I'm going to say, look, as an employer, you should have some sort of vaccination policy in place. If you don't already, now is the time to get something in place. Many big companies, many mid-sized and small companies have said that they planned on making vaccination policies mandatory. If you look at the teachers, the firefighters, and the police in Toronto, at least, that's where this is going. So I would say, if you haven't already, absolutely, you should have a vaccination policy in place. You should consult with a lawyer to understand the advantages and disadvantages, and what the benefits and risks of implementing a policy are. And depending on the nature of your workplace, depending on what sorts of jobs you have available, depending on how many employees are already vaccinated and whatnot, a lawyer can help you craft an appropriate policy. So I'll go through some policy examples to end here, from the least to the most strict, and certainly a mandatory or optional education session can be incorporated into each type of policy. So the least strict type of policy is essentially to encourage your employees to get vaccinated, and encourage them, but not to require them to disclose their status to their employer. So this is actually not requiring anyone to do anything. You are simply encouraging them to report their status, so the employer can determine how many employees are vaccinated, and encourage everyone to get vaccinated. Okay, that's the least strict type of policy. And I would suggest that most employers, if not all employers, probably should at least think about doing a little bit more than that one. The next policy that I'll go through, or type of policy, would say that employees must either be fully vaccinated or be regularly tested. So basically, the option here is prove your vaccination status. If you are fully vaccinated, great. If you are not, if you cannot provide proof that you're fully vaccinated because you are not, or because you are fully vaccinated but on principle don't feel like you should have to provide your status to your employer, then you go into a regular testing type program where you're going to get rapid tested every day, or at least regularly. And finally, the most strict type of vaccination policy would say that employees must be fully vaccinated. The only exceptions are the Human Rights Code ones, so disability, religion, potentially some others, although I'm still not sure what they would be. And then employees who do not comply by the deadlines for getting their first dose or second dose are going to be disciplined. So, for example, would be put on an unpaid leave, or ultimately terminated. And again, I would just caution, if you're going to be terminating for cause and willful misconduct, just be careful, consult a lawyer. Okay, so that concludes the first topic on vaccination policies. And we will now shift gears a little bit, and we will now look at the impact of COVID-19 on the common law reasonable notice period for an employee. Okay, so back to the basics for a second here. An employee who is terminated without cause is going to be entitled to a reasonable notice period at common law, subject to some other considerations on the next slide. But in determining the notice period, we look at a 1960 case called Barlow and the Globe and Mail, and the factors that the court came up with in that case and are still relied upon today are the character of the employment, the employee's length of service, their age, and the availability of similar work having regard to the employee's experience, training, and qualifications. There are a few scenarios in which the Barlow factors would not be applicable. The first one is where the employment is for a fixed term, in which case, if an employee is terminated early, they need to be paid out for the balance of the fixed term, unless there is an early termination clause. Secondly, if there is an enforceable termination clause in an employment contract, then Barlow would not apply. If an employee is dismissed for just cause at common law, then Bartle does not apply because there would be no reasonable notice period. And then finally, if an employee has made an application to the Human Rights Tribunal arising from a discriminatory termination and the matter is being heard there, Bartle doesn't actually apply because the Human Rights Tribunal does things differently. The Human Rights Tribunal would essentially award damages from the date of the termination up until the date of the hearing and less any mitigation. So it's different from the way Bartle works. Let's look at a case here on the impact of the employer's financial situation on the reasonable notice period for context and background. This was a case called Michaela, which was decided in 2015 by the Ontario Court of Appeal. 3 teachers were dismissed by their employer. One of the arguments that was raised by the employer was that they were in a dire financial situation and therefore the notice period should be reduced. But that argument didn't fly with the court. The court said an employer's financial circumstances justify neither a reduction in the notice period in bad times nor an increase when times are good. In 2021, during the pandemic, the case of Yee and Hudson's Bay Company was decided. The employee was terminated well before the pandemic on August 28th of 2019. The case didn't actually make its way till trial until later and was decided in 2021. The court awarded 16 months of common law reasonable notice and concluded it seems clear terminations which occurred before the COVID pandemic and its effect on employment opportunities should not attract the same consideration as termination after the beginning of the pandemic and its negative effect on finding comparable employment. So in other words, because the termination happened long before the pandemic, there's not going to be any special considerations that arise from the pandemic. But then we get a more recent case that was decided in 2021 called Kraft and Firepower Financial Corp. So here the employee began work in October of 2014, and his employment was terminated without cause during the second week of March of 2020. So days before the Ontario government declared a state of emergency. So essentially, right before the pandemic really hits here. The significance of this case is that a termination which occurs during the pandemic or slightly before can increase an employee's common law reasonable notice period. So the court determined in this case that it is noteworthy that the plaintiff was dismissed right at the onset of the COVID-19 pandemic. He contends, and the length of his job search demonstrates that this situation seriously impacted on his ability to find new employment. The court distinguished the Yee decision because of the timing of the terminations. The termination in Yee was in August of 2019, and the court stated at issue here is the job market and the impact of COVID-19 or COVID on that market. And then the court goes on and concludes, especially during the first half year of the shutdown in response to the pandemic, there was uncertainty in the economy and the job market, and fewer employers were looking to fill positions. As a number of my colleagues, so talking to other judges here, have commented, this degree of uncertainty, which existed on February 19th, 2020, is one of many factors that I consider in assessing the reasonable period of notice applicable to the circumstances of this case. So in Kraft, the court looks at the case law for reasonable notice and says that for this particular employee, the low end of the range was 4 months, the high end of the range was 12 months, the average was 9 months. And the court says, well, I'm going to award 10 months, and the reasoning was as follows. There is evidence that the pandemic impacted on the plaintiff's ability to secure new employment. In light of that evidence, he deserves to receive at least somewhat above the average notice period. I would peg the figure at 10 months or 1 month more than the average for his circumstances during non-pandemic times. The court also noted that the employee tried very hard to mitigate. He applied for over 70 jobs in 13 months, but yet was unable to get a new job. So the court did increase the notice period because of COVID-19. The good news for employers, though, is that it wasn't really by very much. We weren't talking, like a 6-month increase. We're talking, a 1 month increase, or, roughly around, 10%, a little bit more in this case. And I'll leave you here with one more case that addressed the issue, called Skoran and ABC Technologies, where the court concluded, in addition to the Barlow factors, it is relevant that we are in difficult economic times at present. I have no indication that the job market for 60-plus-year-old project engineers is particularly buoyant in Toronto during the third wave of the pandemic. So absolutely, the COVID economy is relevant. The courts will take that into account. The good news, though, is that it doesn't really seem, at least yet, to significantly be impacting on the reasonable notice period, at least based on the result in Kraft. And now we are going to move right into the third and final topic of today's seminar, which addresses the employer's duty to deal with employees in good faith and moral damages. So this is another quick case law update as well. There we go. All right, so let's start with an overview of what are moral damages. So moral damages are damages, or in other words, compensation, money, that flow from the manner of dismissal. The employee must prove that the manner of dismissal caused mental distress that was in the contemplation of the parties. This comes from a case called Keys and Honda Canada. The normal distress, disappointment, embarrassment, and hurt feelings that result from a dismissal are not compensable. So it has to go beyond that in order for there to be an award of moral damages. These sorts of damages can only be awarded if the employer engages in conduct during the course of the dismissal that is unfair or is in bad faith. So we're talking things like being untruthful, misleading, or unduly insensitive towards an employee. And a good case which addresses that is called Colistro by the Ontario Court of Appeal. And for extra clarity, when we say moral damages, they are also referred to as aggravated damages and Wallace damages. So we are all talking about the same thing. The terms moral damages, aggravated damages, and Wallace damages really all refer to the same thing. Okay, so in Keys and Honda, which we will look at in a bit more detail later on in the presentation, the court distinguished between punitive damages, which are intended to punish an employer and can be awarded by the court if the court determines that the conduct of a party offends its sense of decency, versus aggravated damages, which are intended to compensate a plaintiff or an employee for an actual loss. Historically, employees were able to obtain additional damages in a wrongful dismissal claim only where the employer's actions during the dismissal were so severe or outrageous that they gave rise to an independent actionable wrong. So examples of independent actionable wrongs would be the tort of intentional infliction of mental distress and defamation of character. So we've talked a little bit about this slide already, so I'm going to power through here. So in 1997, the Supreme Court decided a key case called Wallace and United Grain Growers. And what happened here was that the court held that employers had a duty of good faith towards their employees. They had to act fairly towards their employees in the course of dismissal by basically being reasonable, honest, and forthright with their employees. And for employers who didn't, that they could be liable for an extended notice period. So basically what happened was that the court in Wallace, and what happened later is the courts would say, well, we're going to look at the Barlow factors. The notice period is 4 months, but because of the employer's poor conduct, we're going to increase the notice period now to 8 months. Okay, and the courts were doing that quite regularly. Employees when they were suing their employers were claiming damages for bad faith termination, and the courts were regularly awarding it. And basically, this slide covers the facts of Wallace in a bit more detail. Basically, the employer alleged cause, but then didn't explain it, and ultimately withdrew the allegation, and the court did not like that. Then we get to Honda and Keys, which was decided in 2018. So there was a bit of a concern about how frequently Wallace damages were being awarded. All sorts of bad faith related termination lawsuits were being launched in addition to the normal reasonable notice period. And there were many court decisions in which these Wallace extensions were being awarded. So the court revisited this issue in the case of Honda and Keys. So this slide goes through the facts, or the main facts, of Honda and Keys, but basically what happened was Mr. Keys had a medical condition. His employer wanted him to go see a specialist in order to determine how they should accommodate the disability. Mr. Keys had some questions about what would happen there. Ultimately, he refuses to go and gets terminated, and sues the employer for wrongful dismissal, and it's bad faith conduct. At trial, he does pretty well. He gets a 15-month reasonable notice period, which was awarded based on the Barlow factors. And then the court awards a 9-month extension to the notice period as Wallace damages, which now results in a 24-month notice period. And he also gets punitive damages of $500,000. The Court of Appeal reduces the punitive damages award, and then the case makes its way to the Supreme Court of Canada, and the Supreme Court says, nope, we're going to keep the reasonable notice award for 15 months, but nothing else. So the Supreme Court went on, revisited the issue, and addressed how Wallace damages were to be awarded. So some of the principles that flow from Honda and Keys. So first, if an employee can prove the manner of dismissal caused actual damages for mental distress, they should be compensated for that. The award should be based on the employee's actual losses rather than given as an extension, or somewhat arbitrary extension, I would say, of the wrongful dismissal notice period. Okay, so those were two of the main holdings in Honda and Keys. Let's move on to the next case now. This is a 2014 Court of Appeal case called Boucher and Walmart Canada. So this is another example of aggravated damages being awarded. Basically, what happened here was we have Boucher, who was a very good employee, gets along with everyone. She herself worked as an assistant manager. Things, unfortunately, take a very bad turn for the worse. When her boss asks her to falsify a temperature log, she refuses to do so. He starts belittling and humiliating her, treats her very badly. The employee, Boucher, tries to have the matter addressed through Walmart's policies. The company doesn't follow its own policies. The treatment gets worse, and she eventually stops coming to work and claims constructive dismissal. At trial, Boucher is awarded a lot of money, including $200,000 in aggravated damages against Walmart. The case goes to the Court of Appeal against Pinnock, who is the supervisor. The court awards a total of $110,000 against Pinnock. Let's focus, though, on the award, the aggravated damages award against Walmart. The court holds that $200,000 in aggravated damages was justified on several grounds, and the relevant conduct was that Walmart failed to take Boucher's complaints seriously, failed to discipline Pinnock or stop the ongoing mistreatment of her. Walmart failed to follow and enforce its own workplace policies, and it threatened Boucher with retaliation for making her complaints. So this is an award, again, of $200,000 in aggravated damages against Walmart. We're now going to move to, by coincidence, or perhaps not, another case involving Walmart. This one's called Gale in Walmart. And this involves a case where an employee was awarded a total of $750,000 in total damages. Of those, $250,000, were the moral damages. So the facts here: the employee began working at Walmart in 2002 as a district manager. She did very, very well, got numerous promotions. She rose very quickly through the ranks. She was considered to be a valued employee, and she gets promoted to vice president. 2 years later, she's informed that her position had been eliminated. As we'll see later, all Walmart should have done was terminated her without cause, paid her severance, and this case probably wouldn't have been decided in the way that it was. But instead, Walmart assures her that she's a valuable employee. They'll find her another position. But she eventually, after being sort of jerked around a little bit, she eventually gets demoted to a position with no duties or management expectations. And finally, not until November of 2010, she's told that her employment has been terminated. Based on her contract, because it was a without cause termination, I believe the contract said that Walmart was supposed to pay her 12 months of notice, or perhaps more. But in any event, for some reason, they stopped her salary early after 11 and a half months. And they also canceled all of her health and dental benefits without informing her. And I believe as well there was some other conduct in which Walmart engaged, which, frankly, wasn't so nice, to say the least. I think while Galea was away, they basically cleared out her office and without telling her, and she came back, and all of a sudden all of her stuff is gone. So for some reason, this was just not dealt with very nicely by Walmart. And ultimately, here's a breakdown of the award. But she gets $250,000 in aggravated damages. Okay, the court goes through in this case the test for aggravated damages. I'll leave you to go through this slide later, but this is from the case about what factors the court was looking at in the award of aggravated damages. Okay, so that's another case about Galea. And here, this slide again, addresses some of what the court had to say about Walmart's conduct. Walmart's conduct was misleading at best and dishonest at worst in the way the company treated Miss Galea. Okay, only Walmart knew that Miss Galea's career was over long before she was actually terminated. To keep her in suspended animation was unduly insensitive conduct. The 10 months she was left to seek a new foothold qualifies as a manner of dismissal that caused Miss Galea mental distress and qualifies her for aggravated damages. And then the court goes on about some of the post-termination conduct. So it's $200,000 in moral damages for the pre-termination conduct, $50,000 for the post-termination conduct, in it for a total of $250,000. Okay. In the interest of time, we are going to move to now the case of Russell and the Brick Warehouse, which is the most recent case here. So in this case, the court awarded $25,000 in moral damages because the employer breached the duty of good faith and fair dealing at the time of and following the employee's dismissal. So essentially what happened here was we had a termination without cause, but the employer messed up in the following ways. First, the termination letter did not expressly state that the employee would be entitled to their ESA minimum entitlements no matter what. So regardless of whether they signed a release in exchange for a slightly enhanced severance offer. The other problem was that the employer did not continue long-term disability benefits and vacation pay throughout the ESA statutory notice period, despite their obligation to do so. And finally, even though the benefits, or at least most of the benefits, were continued throughout the statutory notice period, that was not communicated to the employee in the termination letter, and it wasn't actually confirmed for some reason until 7 months after the termination, long before or long after the benefits had already expired. So in the case, the court goes through all of the relevant factors that it looked at in determining whether there should be an award of moral damages. And the court cites the Galea and Walmart decision that we just looked at. So it all comes down to, the employer's conduct and the mental distress, that goes beyond the normal hurt feelings that would be experienced by the employee. Okay, so $25,000 in moral damages was awarded. Here's a summary of the court's reasoning. A lot of it comes down to, really lack of transparency, lack of fair dealing, and failure to comply with the Employment Standards Act. And I'm just going to end here. I'm just going to draw your attention to this slide here. On the topic of dealing with employees in good faith, the next few slides contain some tips, for you to look at about, terminations and terminations meetings. I'm just going to jump to the last one here. Really, it's important to have a lawyer either draft or at least review a draft of a termination letter before it gets sent out, just to make sure that you don't fall into the same trap that we talked about here in the Russell case, or that there's something, missing in the termination letter, because, there was a combination of things that sort of went wrong, in this termination. But $25,000 extra beyond the reasonable notice period, is a lot. So having a lawyer review or draft the termination letter for you can go a long way in saving some money. So as a final takeaway here, just be respectful when terminating an employee. You have an obligation to deal with employees in good faith. So just make sure to do that, and always consult a lawyer. when dealing with the termination documents and in the ultimate decision to terminate. So that concludes the presentation. So in just a moment, we are going to take a break until 10:15. I will review all of the questions that you may have submitted in the next 15 minutes, and then I will come back online at 10:15 to answer as many of your questions as I can in that time. Thanks very much. Enjoy the break, and I'll be back soon.